Civil rights. So, what are civil rights exactly? Civil rights are different from civil liberties. So, we've talked about civil liberties. Civil rights, another part of this coin, are protections designed to protect people against arbitrary or discriminatory treatment. The United States is founded on the idea that all men are created equal, and the struggle for equality has been a persistent theme in American history. Slaves wanted freedom, and later African Americans have been striving for equality. Women strive for equality with men. Economically disadvantaged people struggle for economic opportunities. Homosexuals, senior citizens, the disabled. So there are a number of groups that have been striving for equality, and our conceptions of what equality means has changed over time. And a bit of a malleable concept, but also our understanding of different groups of people and how they might be trying to achieve equality. So what does it mean? What does equality mean? Does it mean that we are all the same, or all alike, or all the same, we're entitled to all the same things or results? Equality in the United States means a couple of things. The first is that everyone is born with inalienable rights. Pretty simple. And the second, which flows from these inalienable rights, is that everyone is entitled to the equality of opportunity. So, equal opportunity is the way we have been interpreting what that means. So, how do we define and measure equality? If you think about it, does it mean we get the equal results? Do we get equal rewards? It's equal opportunity. And how do we test and look at equality? So, for example, does equality mean everything is the same? Well, no, not exactly. So, for example, if everything was the same, let's say that the rule was everything had to be equal, so that people could watch a baseball game over a fence. And I'm 5'8", and my friend is 4 feet tall, and my other friend is 7 feet tall, and the fence is 4 feet exactly. And so my friend, who's 4 feet tall, can't see the game because his eyes are at level with the fence. But the law says we have to all be able to equally see the game. So does that mean that my friend is given a 1 foot tall box to stand on, and I am not given a box, nor is my other friend, because he's 7 feet tall and we can both see the game easily? Or does it mean that because he got the box, we all get the box? The way we've been looking at the law, and one of the ways that has changed over time, is that the definition of equality for many means that you don't all need to get the same box. But if the law says you're all supposed to see the game over the fence, it means that sometimes people might need a 1 foot box, but others don't. And what does this do? It grants the equality of opportunity, not necessarily the equality of result. So, how does this get applied historically? We shall see. The Constitution does not mention equality. It implies it by refusing to limit the guaranteed rights to any specific group. The 14th Amendment was ratified after the Civil War to prevent states from discriminating against former slaves. It forbids the states from denying to anyone equal protection of the law. And by anyone, they meant African Americans, but it also means anyone and everyone. So this is a very powerful amendment and a very powerful statement. Now, the judicial system has a series of tests to determine if a law violates the Equal Protection Clause of the 14th Amendment, which we have seen already. Any classification must bear a relationship to a legitimate government purpose. So that is, it must be reasonable and not arbitrary. So just decided, without any standards, and it must be reasonable. So, a law that restricts voting to citizens over age 18 passes constitutional muster because age is a reasonable classification for voting. A law that only allowed those with blue eyes or red hair to vote would be arbitrary and unconstitutional. Why would the age be reasonable in this case? Because, for example, if you ask, say, a law for 5-year-olds to vote and there be opposition to that, or say preventing 5-year-olds from voting, it's because 5-year-olds are not fully formed individuals and are under the protection of their parents, and therefore their mental capability to make clear voting or clear decisions in voting is not there yet. So you're expecting that by a certain age, people should have that conception in their mind, or that ability in their mind. But having blue eyes or red hair does not have an impact on your ability to vote. So that would be unconstitutional. Some classifications, like those based on race or ethnicity, are considered to be inherently suspect. So one test is saying, is this inherently suspect? In such cases, the burden of proof is on the lawmaker to prove that there is a compelling public interest and that there is no other way to accomplish the legitimate purpose of law. In the case of this was being brought to court, the burden of proof is on the defendant, not the prosecution. So in this case, it's the lawmaker who has to provide the burden of proof, saying and show that there is a compelling public interest and there's no other way to accomplish the legitimate purpose of law. It is virtually impossible for a law to pass the standard. Can you imagine a legitimate law that discriminates on the basis of race or ethnicity? What sort of compelling public interest would it serve? I can't think of one. So if you can, I can't think of one. So it's nearly impossible to pass this. Laws that discriminate on the basis of gender have a lower standard to meet. They must bear only a substantial relationship to an important government purpose. So the law, for example, restricting the military draft to men has been upheld as constitutional under this standard. So it's called there's an intermediate scrutiny test. So they must bear only a substantial relationship to an important government purpose. It's a lower standard than the racial and ethnic test. And the law restricting the military draft is such an example. Age, it just has to be reasonable. So is there a rational relationship to a legitimate public goal? And what we have just seen with the voting age is, yes, there's a rational relationship to that public goal. Gender is an intermediate scrutiny test, right? It's tougher than the age test, not as tough as the racial and ethnicity test. There's no presumption made. So it has to just be an important governmental goal. So that's how those pass, and race and ethnicity have a high test, high standard. Inherently suspect they are. Here's a little chart to sort of help sort it out. Race and ethnicity classifications. The standard of review is inherently suspect. It is a difficult test to meet. Is the classification necessary to accomplish a compelling government purpose and the least restrictive way to reach that goal? That's the test. Gender. It's the intermediate scrutiny. Does the classification bear a substantial relationship to an important governmental goal? That's the question you have to meet. So, military draft meets that goal. Other, age, wealth, etc. Reasonableness. Is it reasonable? This is a fairly easy standard to meet. Does the classification have a rational relationship to a legitimate government goal? Okay? And that is what you're looking for. We'll take a look at a few issues within civil rights and talk a little bit about them from a historical standpoint. So, Civil War amendments. The 13th, 14th, and 15th Amendments that passed after the Civil War. The 13th Amendment ending slavery. The 14th providing for equal protection under the law, and the 15th, providing for the voting rights. All were targeted at freedmen, freed slaves, but they apply to everybody, right? In this case, the 14th Amendment is a very powerful amendment, as we've seen, that applies to all Americans, right? Because it says, while it may have been intended to target freedmen, it says that anyone born and naturalized in the United States are citizens of the United States. Why is that even necessary in that wording? Well, let's take a moment and go back over some cases. Key cases and policies in civil rights history, especially regarding civil rights of African Americans. In 1857, in the case of Dred Scott versus Sanford, in a landmark Supreme Court decision, and one that was a prelude to the Civil War, what happened? Dred Scott, who had been owned as a slave and had been taken across the country by his owner, who had been an army surgeon, and his wife, when they entered a free state territory, Dred Scott claimed that he was now free because they had entered a new state, a territory that did not have slavery, and therefore he was free. This went to the Supreme Court. His owner's name was Sanford. This went to the Supreme Court in 1857, at which time the Supreme Court decided, and the majority opinion was read by Chief Justice Roger B. Taney. Justice Taney said that, one, Dred Scott was not free. That, in fact, the Constitution gave no authority to Congress to create a line, an imaginary line, or any boundaries in the United States deciding what states were slave or free, and basically overturned the constitutionality of the Missouri Compromise line of 1820. It also said that the federal government did not have the power to interfere with slavery in the states, and that this was a state issue. And what's more is he said that Dred Scott was not a citizen of the United States and therefore had no right to bring suit in court. So he said that enslaved Africans were not citizens; they were slaves, and therefore could not bring a suit in court. And he added a famous final statement, an obiter dictum in Latin, in which he said that no black man had any rights that any white man was bound to respect. That was the prevailing opinion of this case. So when you look at the 14th Amendment, when it says that anyone born or naturalized in the United States is in fact a citizen of the United States, what is this amendment trying to do? It is directly aimed at the precedent founded in that decision of Dred Scott versus Sanford, where it says, of course, all black people who are born or naturalized in the United States are citizens of the United States, and that, yes, that decision is now overturned, abrogated, over, because the Constitution says it. It says you are a citizen of the United States if you are born or naturalized in the United States, regardless of your race, your ethnicity, or your previous condition of servitude. So if you used to be a slave, you are now a citizen. So that amendment is worded in that way precisely to address the question of that case. So thankfully, that case has now been wiped out. But it doesn't put everything in the clear, because, you see, in the days after the Civil War, while the South was under military occupation, something interesting happened right after the end of the war and the surrender of southern states. For example, in South Carolina and in Louisiana and in Mississippi, a number of states started to pass what were called black codes. Now, these codes, they were passed within the year, 1865, 1866, early 1867, and then were wiped out. But in those early years, what these states did was they said a law or regulation to protect the civil rights of freed men. The freed slaves, right? Because the 13th Amendment had been ratified, had been passed, and so now slavery was over. But what these really were ways in which they could write slavery into law in everything but name. So it basically said that blacks could not assemble, could not bear arms. If they were walking through town, they had to be carrying papers that said they were on business from their boss. That if they failed to meet any of these tests, they had to pay a heavy fine or serve prison sentences in hard labor gangs, in which they would often be loaned out or sold. Their labor would be leased out to local plantation owners. So basically, it found a way to basically recreate slavery in everything but name. Those black codes were overturned when Congress took control of Reconstruction by 1867 and imposed a military Reconstruction in the South, which meant the South would be cut up into military governance zones and would be governed by the military until such time as civil government could be restored. Under military control, meaning at the barrels of Union rifles, African Americans experienced probably more freedom and civil rights in the South than they would until about 1970. So what was this? Well, as the Union was enforcing the law, that meant they overturned all black codes in these states. Also, the Congress had supported a growth or an increase in military presence in the South, especially in light of combating Ku Klux Klan violence, which became a problem. So there were attempts at threats and intimidation of black voters, and blacks were allowed to vote. They were that was protected and could vote under the protection of the military. In fact, you have African Americans going to Congress, being elected as politicians in states, as new state legislatures, and going to the House of Representatives. However, this was short-lived, as in 1877, as part of the compromise to become president, Rutherford B. Hayes officially ends Reconstruction. And with the end of Reconstruction, you have a restoration of white order. And by the 1890s, what you get is a series of codes that sort of restores this white order. Now you say, well, what happened to maybe people in the North who were sympathetic and to the cause of protecting African American civil rights? They weren't all that keen on protecting African American civil rights in the North. So, racist policy is racist policy, whether it's North or South. And so you see it in both places. And in his recent book, Race and Reunion, historian David Blight talks about how the memories of the Civil War start to change by the 1890s. And you have this reconciliation between Northern or Union veterans and Confederate veterans in this rewritten, totally BS story of the Civil War, in which two groups of two white armies basically fought over important constitutional arguments in an honor-filled and glorious fashion, that they had done heroic deeds and all of these sorts of things. However, they have moved beyond that. Reconstruction was actually a horrible, horrible experience that allowed for African Americans to take control of the South, and it was a deleterious and horrible process. And now blacks were taking control of state and local governments, and this was a threat. And so now, by the 1890s, you have whites from the North and the South sort of commemorating this honorable thing they did in their youth. That was an important and influential event, but also one that they can now share and bond about, where the former enemies used to be at each other's throats. Now they could both commemorate that honorable experience, and unfortunately for African Americans, it meant that both could basically regard that Reconstruction was this horrible, horrible thing, and both could agree to continue to discriminate against blacks. And what you have in 1896, in the case of Plessy versus Ferguson, is a Supreme Court punctuation mark on that sentiment or feeling. Because in 1896, Homer Plessy sued Mr. Ferguson from a local railroad company, suing against basically segregated railroad cars. This made it all the way to the Supreme Court during military Reconstruction. There was no such segregation allowed, which meant that public facilities, train cars, trolley cars, theater seats, all these things could not be discriminated or segregated. However, as the military left, this became the law of the land. Whites dictated the grounds upon which any white and black interaction would happen. Transgressions of any kind would be reinforced by a resort to violence that would not be really punished in any legal fashion. So lynching, this public violence, would not be punished. So in 1896, what did the Supreme Court say in Plessy versus Ferguson? It said that the separation of facilities in discriminating facilities was absolutely constitutional, that Homer Plessy's civil rights were not violated, and that despite whether he says that it makes you mentally feel bad by being discriminated against, he said that that's not the concern of the court, and that no such feelings should be taken, and that if anyone wants to feel bad, they're making themselves feel bad. It's no one else doing it, and that as long as facilities were separate but equal, they were constitutional. This basically established the constitutionality of segregation, making it basically the law of the land up until 1954. So from 1896, that's 4 plus 54, that's 58 years. For 58 years, segregation is the law of the land. Everything in the United States is segregated, north and south. It's not just a north thing. Now the NAACP had been working on a series of test cases that would erode this decision. In 1950, it made headway in the case of Sweat versus Painter, which basically argued against a block on African Americans from attending professional schools in the state of Texas. And what the Supreme Court said is that since there's no comparable professional training facility in the state, then African Americans had to be admitted to the white school, so you couldn't discriminate. But in 1954, in Brown versus Board of Education, Chief Justice Earl Warren understood the need to sort of overturn this segregationist policy, and also understood that if this was a split decision, that there would be controversy. So he also understood the need to have a unanimous Supreme Court decision to show how common sense it should be that segregation is, of course, unconstitutional and is indeed, yes, a violation of one's civil rights. He lobbied the other justices, he worked at, and he got a unanimous decision, for which he read the majority or the unanimous opinion, that in fact separation but equal is inherently unequal, because what would happen is our facilities really equal even when they are equal in books, equal in materials, equal in everything else. No, they are not. They don't present the same opportunities. They try to present one group with a negative feeling and treat them negatively in a negative fashion. It does not provide equality. It upholds inequality and therefore is unconstitutional. And then said that schools needed to desegregate with all deliberate speed, which started to happen in some schools. And one of the things that schools had to do in order to desegregate was they needed help in some cases. Very famously, President Eisenhower sent in the airborne soldiers to accommodate black students into forcibly desegregating schools to protect them. So this also brings up another issue about the Supreme Court, which we'll deal with later. Who enforces Supreme Court decisions? The Supreme Court has no enforcement mechanism. It controls no enforcement wing. It is up to the executive office or the executive branch of government, the presidency, to enforce such decisions. President Eisenhower made sure he did. How quickly or rapidly did this happen, by the way? Well, here's a little chart to give you an idea. The Brown decision takes place in 1954. So if we see here, we have 1954. Right here. That's where we start. Notice very minimal throughout, right? Almost no growth, right? Then up by the early 60s, you start to have some, right? And then a little spike. Where's the real spike? Okay? In some cases, right? 68. 14 years before you start to even see 30%, right? 30% of these schools desegregated. And then you don't get the major impetus for another few years yet. So 1970, 71, right? You get a lot. And then you don't have 90% until, I hate to tell you this, you don't even have 90% until a certain event takes place. I, your instructor, am born in 1974. So in other words, for 20 years, this was supposed to be the rule, and for 20 years, you don't even get to 90% until about the year that your instructor is born. So what is meant by all deliberate speed? Now, this is in the South. You have better stats in the North. So to give you an example, the last institution I worked at was in rural southern West Virginia. Okay, they did not integrate their public school system. Their public school system wasn't really fully integrated, or even really integrated, until 1970. It was the last major county in the state to integrate. And I worked at a historically black college. So it was a historically black college surrounded by segregated schools. The Vietnam War is going on, everything else going on. Man walks on the moon before you. The year we first land and walk on the moon, okay, is I'll highlight the moon shots. So if you take a look here, okay, 1969. We have man on the moon. Okay? 30%. Right? 30%. So, even when the Supreme Court issues these things, it takes, a long time. Now, there are other ways of acting on this. Now, there was the Civil Rights Act passed in 1964. And the government has spent a lot of time trying to uphold it. Same with the Voting Rights Act, trying to, once again, reassert the rights of people to vote. Now, because of the 15th Amendment, many southern states took great pains to make sure that black voters could not vote. How did they do it? One, charging taxes to vote, called poll taxes. They are now unconstitutional and illegal. But the idea is that making you pay a tax in order to vote. If you couldn't pay the tax, you couldn't vote. So what would they do? They would try to come up with a sum that most African Americans couldn't pay. White primaries, saying that, yes, African Americans could vote. However, in the South, the Democratic Party was the solid party of the South from basically the 1832 up until the 1930s. So at that point, and then even then, well, it was still really the solid party of the South up and through 1969. Sorry. There's a realignment in the South politically, which we'll talk about later in the course, around the election of 1968. And it becomes predominantly Republican through the 70s and 80s. But solidly Democrat from 1832 to about 1968. So That meant if you were a Republican in the South during that time, the chances of you getting elected in the general election were basically none. So the real decision, the real election took place during the primaries. Who would be the Democratic representative? Well, if you close off the primaries to African American voters and that allow them to vote in the general election, they can vote for Republican candidates all they want. The chances of them getting their candidate in office are slim to none. Others were simple intimidation, so trying to intimidate black voters by threatening violence if they showed up to the polls. One of the strangest and also worst in tools was called the poll test. Some states would require that voters had to pass a literacy test, and there are all sorts of ways of doing it. And I will show you, and we'll go through an example right now. This is an example of a literacy test, a poll literacy test. And it was there to be given to anyone who cannot prove a fifth grade education. Well, now I want you to think of a few things. During the era of slavery, it was illegal. It was a felony in most southern states to teach a slave to read or write or send them to school. And then after the war, schooling was shut to a number of black students. So basically, you don't have many opportunities to get a third grade education, let alone a fifth grade one. So that would mean that most black students or African Americans through parts of the later 1800s would not be able to provide a fifth grade education pass certificate, so they would wind up being forced to take this test. Now let's take a look at some of the questions and see how this might be a good or bad judge of your fitness for voting. Draw a line around the number or letter of this sentence. Now you're asking, okay, I've drawn a line around the number or letter of this sentence. Draw a line under the last word in this line. Okay, cross out the longest word in this line. Draw a line around the shortest word in this line. Circle the first letter of the alphabet in this line. A. In the space below, draw 3 circles, one inside, engulfed by the other. Sorry, it's freehand. Here, I'll make it pretty in this using this cool draw tool we got, right? Here's the tool. So here. 1, 2. Oh, it looks like an eye. Okay, now it looks like a freaky eye, but same idea. Above the letter X, make a small cross. Draw a line through the letter below that comes earliest in the alphabet. So, right? Draw a line through the 2 letters below that come last in the alphabet. In the first circle below, write the last letter of the first word beginning with L. Right? In the first circle below, write the last letter of the first word beginning with L. T. First word begins with L, is last. Cross out the number necessary when making the number below 1 million. Right? So let's see what we have here. There's 1, 2, 3. Well, let's just put little commas in here to make it easier for you to read, right? 2, 3. Of course, you can't do this on the actual test because they'd say that that would make your answer wrong. So 1, 2, 3, 1, 2, 3. So what we have is 1 billion, and if we cross out these, we make the number below 1 million. So draw a line from circle 2 to circle 5 that will pass below circle 2 and above circle 4. But we have to draw the line from circle 2 to circle 5, and we want it to go above circle 4, circle 5. In the line below, cross out each number that is more than 20 but less than 30, right? So you get the idea. Now, we can do this, and not everyone gets these right. They're worded in strange ways, intended to trip you up, and you have to do it in 10 minutes. Now, leave in the directions. Do what you are told in each statement. Nothing more, nothing less. Be careful, as one wrong answer denotes a failure. You can't get one answer wrong on this test. Now, I just showed you the first page, but there are multiple pages. I think there's 30 questions? I think there's 30 questions on this test. So you can see how if you have people who are not literate or not very well read or haven't had much education, these can be quite confusing. And what does this have to do with appropriateness of voting? It doesn't. It's designed to discount you or throw votes out in a way that is not immediately overturned as unconstitutional. And that's what the state of Louisiana did with this test. But other states had it too. So that was a poll test. Others were grandfather clauses, which were clauses that said if your grandfather had voted in the election of 1860, you were eligible to vote. So basically that would automatically prevent blacks from voting because in 1860 it was the last election the South participated in before the Civil War, before secession. And it was the election of Abraham Lincoln. And so if your grandfather had voted in that election, it also meant that he was white. 8-box ballots. 8-box ballots were another confusing system as a way of disallowing votes. And in this was really targeted at confusing especially illiterate voters. Once again, it's kind of like the poll test, which is designed to confuse. So basically, voting was not done in private booths at this time. It was done publicly in front of everyone. And you'd have these boxes up for each office. And you would have your name on a ballot that you would drop in for each candidate that you approved. You'd be dropping your official ballot into that box for that office. What they would do would be to have the boxes all up in a number of different there, and then have them all written, and basically you'd have to put your ballot in the correct box. Now, for each office, so if you were voting for so-and-so for this office, you had to have your ballot in the correct box. If you failed to put your ballot into the correct box, it nullified not just your vote on that office, but all of your votes on every office. And since your name was on your ballot, they could do that. So the idea was to confuse semi-literate or illiterate voters from being able to vote. Next, we'll look at women's rights and women's suffrage and the Equal Rights Amendment and women's equality. The first women's rights convention, held in Seneca Falls, New York in 1848, culminated in a document that looks like the Declaration of Independence. And that was it's called the Seneca Falls Declaration. And it just took about 72 years of activism before the 19th Amendment, which guaranteed women's right to vote, was passed. So, in fact, only one signer of the Seneca Falls Declaration was alive to vote after the 19th Amendment passed. So that's how long it took. The 19th Amendment secured women's rights to vote in all federal, state, and local elections. Now, before that point, there had been some Western states in which women already had gained suffrage. Remember, it's states that pass voting laws. So why was this? A number of Western states had wanted to become states instead of remaining territories. In order to do this, they needed to meet a certain adult voting population, and one way to accomplish that was if you declared women as voters, then you would have had the adult voting population necessary to qualify as a state. That's one of the main reasons. The other is that it recognized in code what had existed in fact, is that in a number of these small communities that women were taking on leadership roles out of necessity and out of practicality, and that's how things were, and so it was just recognizing in law what already existed in fact. So that's why this took place. Now, getting the right to vote is the first step. And in fact, there was a big disagreement over that. Women are still far from achieving full voting rights equality and ending those differences both in code and in fact. One of the reasons that there's been great trouble in achieving those ends has been great disagreement. For example, an Equal Rights Amendment was proposed in 1923, which basically said that women would have the same rights as men, that women would have equal rights as men. But the question is, what does this mean? Because not all women supported it. And you're saying, why would that be the case? A number of feminists argued that, in fact, the Equal Rights Amendment would actually hurt women more than help them, because at that time so many women were working women that one activist, Ethel Smith, had argued from a labor standpoint that said, actually, if you want to really worry about women's equality, address equal pay for equal work and equal working conditions, and you will have gone much further in achieving women's equality. Alice Paul, who was the outspoken leader of the Equal Rights Amendment group, came from a more privileged background, not a working class background, and from her perspective, an Equal Rights Amendment would have been more beneficial. But you have this disagreement among women activists themselves. So it's one of the reasons the Equal Rights Amendment failed when it was proposed in 1923, and it was reintroduced years later in the 1970s and still did not get ratified. So today there is no Women's Equal Rights Amendment in our Constitution. Laws in the past had limited women's work hours, restricted their activities, supposedly for the protection, but it was really to enforce sort of a prevailing social view that women should be devoting their time to home, to family, to their children, and also to prevent women from competing with men for jobs. In divorce settlements, when women could sue for divorce, women could get custody of their children, but this was basically in keeping with the idea that women should be at home caring for children, and that was sort of the premise of that. When the Equal Rights Amendment had been introduced in 1923, a number of women and men and women, actually didn't welcome it. They saw it as a threat to the family. And so a number of people thought it was a radical idea and didn't get that much support. It was only got introduced that second time after sort of a second wave of feminism arrived in the 50s and the 1960s and aligned itself, while people were taking up the cause for the rights of minorities, so seeing the same issues parallel for women and using some of the same techniques for advocating for women's rights. A new women's organization, an advocacy organization called the National Organization for Women, came out during this time period and had started to generate legal challenges of gender-based discrimination. In 1972, in the case of Reed versus Reed, the Supreme Court declared arbitrary discrimination on the basis of gender was a violation of the Equal Protection Clause of the 14th Amendment. So 103 years after the ratification of the 14th Amendment, the The Supreme Court reached this conclusion. 5 years later, in the case of Craig versus Boren, the court developed the intermediate scrutiny standard, which we talked about earlier. So there are plenty of defeats for women as well as victories. Congress had passed the Equal Rights Amendment in 1972, sending it out to the states for ratification. It ended up 3 states short. So what you have also is addressing issues of women at work and equality and the idea of equality versus equity. In other words, does equal rights mean equal treatment for all? The example we talked about at the beginning of this lecture, or does it mean that people are treated fairly, but maybe not exactly alike? So in other words, one person might need a 1-foot box to stand on, but others don't. But you have the equality of opportunity for all. All can watch the baseball game. So that's the idea. The Civil Rights Act of 1964 had banned some gender discrimination in employment. And employers cannot exclude pregnancy and childbirth from their benefits plans because of the Pregnancy Discrimination Act of 1978. Women are also protected from being required to take a mandatory pregnancy leave and from being denied jobs because they are pregnant. But once again, this was hard fought. And Title IX of the Education Act of 1972 prohibits gender discrimination in federally funded education programs, including athletics. So, once again, this discrimination is hard fought. There's these laws and codes, and once again, it also goes back to this: equality versus equity, maternity leave. Some women, why should women get maternity leave? Men don't get maternity leave. That sort of thing. But now men can take a family leave. So. One of the most persistent aspects of gender inequality has been wage discrimination. Generally speaking, women are paid far less than men for the same job. They earn about 80 cents for every dollar a man earns in a job. And so there have been a number of laws addressing pay equity, though this has been slow in arriving. Sexual harassment in schools and workplaces is forbidden by the Civil Rights Act of 1964. It's a form of gender discrimination, and defining it has been challenging, but there is a definition of it. And the court has said that the law is violated when a reasonable person would perceive the workplace environment to be hostile or abusive. Employers are prohibited from retaliating against employees who report harassment, like a whistleblower type protection, though this has been difficult to enforce and retaliation still takes place. So, not always great achievements in terms of civil rights, still a number of problems of protecting them. A few basic cases that I look at, key case studies and policy questions. In 1944, the case of Korematsu versus the United States was a lawsuit on behalf of Japanese families who had been dispossessed of their property when they were interned. And during the Second World War, there was an executive order which rounded up Japanese families on the West Coast and interned them in the interior of the United States in camps, basically fearing that they might give aid and comfort to the Japanese or serve as spies, that they were a national threat. When they were taken to these camps, their property was repossessed by the government, and when they were released, they wound up going to their old homes and businesses and finding new occupants there. And they were never compensated for this. And they argued constitutionally that they should be compensated based, on the Fifth Amendment, that they were denied their due process and they were not given their money. They were denied their property without just compensation. And in that case, the Supreme Court found that because of the emergency posed by the war, they were not entitled to anything. This did not get settled until the 1990s, when the Supreme Court did find in favor of the internment victims and did award financial damages to them. Still, it took, these were the children of the people interned. Some of them had been interned as children, but you're talking, 50 years of wait for this to work. the 1978, the Regents of the University of California versus Bakke. This is one of the more popular cases. This is what happened. Bakke was a white applicant who was denied access to medical school at the University of California, even though minorities with lower test scores were admitted, while he was not. So basically, he argued that they were trying to, make allowance for affirmative action. The idea of affirmative action is that basically is that you're trying to advocate and get more minorities in positions in the workplace. That's true, but it's not supposed to be a quota system. The idea is that when you have similarly qualified people up for the same job, that you can look to meeting your diversity needs. And here, Bakke argued that this was simply the University of California writing a quota system, and he sued on 14th Amendment grounds, saying his equal protection was being violated. He claimed that he was being discriminated based on race, and he won a partial victory. In his case, the Regents of the University of California versus Bakke, the court ruled that racial quotas were unconstitutional. They are unconstitutional. You can't have racial quotas. But it stopped short of saying that the university could not use race as a criterion for admission. So what does that mean? It means that when you look to affirmative action, that this is something that's not meant to be a quota. It's meant to take. When you have people who are similarly qualified, you can then say, "Hey, look, we have no minorities working here. Let's give somebody a shot." It's not giving something out. It's trying to protect a space to prevent workplace discrimination, or at least hiring in discrimination in hiring. That's the Bakke decision. And another later case, Adran Constructors versus Pena. The court held federal affirmative action programs giving preference for contracts to minority-owned firms to the inherently suspect standard for racial classification, which limited their potential impacts. So the court has not necessarily been very friendly to quota-type systems. So public opposition to affirmative action continues to grow. Several states have banned affirmative action programs. In California, Proposition 209 started to end affirmative action programs. Michigan has tried to end affirmative action programs. I just think that when you look at it in totality, the idea is behind affirmative action. There's a lot of confusion. Most people assume that it's a quota or some festival to take away opportunities from white people or something like that. It really needs to be seen for what it is, which is a way of providing opportunities for traditionally disadvantaged groups that normally face serious obstacles in hiring due to lingering discriminatory practices, both personal as well as institutional, and that the goal is not to make quotas, but to give opportunities to qualified candidates. It's not a special consideration. Once again, the idea of equality versus equity, right? The idea that equity is sort of the standard where maybe the one person needs the 1 foot box, but it still results in the same equality of opportunity. Another important case in 1997 is the United States versus Virginia. In this case, a group of women sued the Virginia Military Institute, a long-standing traditional military university or college in the state of Virginia that did not allow women there. They had established a separate academy, university for women, but women were not allowed there. And they argued that since they were a private school, they did not have to. Well, they're not really all that private. It's a part of the state system in Virginia, but that since they had a separate facility, that would be enough to meet the accommodation needed for women, so that they were not discriminating. In the United States versus Virginia, however, the Supreme Court found otherwise, saying that the separation of these two facilities was not something that provided for the equal status or protection of women, and that the new academy would not have the same reputation or opportunities for women, and that the Virginia Military Institute needed to admit women if it was to remain a state school, that was required. So, in this case, once again, equal protection clause of the 14th Amendment, and the idea that in this case there was no real policy need that could justify the separation, and it had to provide the same equality of opportunity, which it was not doing. Now it would. So, some key case studies, and then when we think of how far do civil rights go, we've already talked a bit about affirmative action, and then how about women in combat or in the draft? There's been a number of opponents over women in combat or women in the draft, and right now women in the draft are not allowed in the draft, and that has been exempted. But how far will this go? Based on our discussion, I'd like you to think about it. And so what we have is our end of our discussion on civil rights. Certainly an important part of our democracy as it functions, and has a story of a long struggle to continue to enforce those.